Hello, Ainsley. Thanks for contacting ILL CPF firm regarding your notice from IRS. We are delighted to have you as our client. Your notice from IRS was issued under Section 6672 Treasury Fund Recovery Penalty. The Treasury Fund Recovery Penalty is a penalty imposed on Cuba toothpaste for either not collecting employment taxes from the employees or for collecting employment taxes and not remitting those taxes to IRS in a timely manner. The IRS also believes that you willfully fail to collect or pay the employment taxes. In the IRS definition, willfulness is defined as someone who was aware of the outstanding taxes but intentionally acted against paying for the taxes. The TFRP is a penalty that cannot be discharged even if a company declares bankruptcy. In this case, our team of tax experts have done detailed analysis, thoroughly studied your notice from IRS, and researched multiple court cases similar to your situation. In our memo, we'll help you to understand this section TFRP 6672, reason why penalty was imposed against you under this section, provide you a draft letter to appeal against IRS. We will also guide you on the next steps after submitting your appeal to IRS. This video is an overview of your case. This case was analyzed by Accy 505 Fall 2020 D14 group of tax consultants consisting of Senthil, Alex, Jeremy, Angela, and Hisa. Thank you.
Ainsley, the IRS will argue that you are responsible for paying $20,000 under the trust fund recovery penalty. They will have to prove that you are both a responsible person and that you willfully withheld taxes from the government. They will attempt to argue this on a couple of different points. First, since you were CFO and treasurer, you were an officer who held the title of someone who would be responsible for paying and collecting income taxes. Second, you are an owner and an officer, even though your ownership stake was very small. Third, you had the ability to hire and fire other employees. Fourth, you had the ability to sign checks on the company's behalf. Lastly, you signed income tax returns for a quarter and a full year in which no taxes were paid. Even though you were not aware of what was in the income tax returns or that taxes were not paid, you certified them by signing them. While we believe that the IRS may have a case to prove that you are a responsible person, we do not believe that they will be able to prove that you willfully withheld taxes from the government. Even though you were CFO and treasurer, you were not privy to the financial information or dealings of the company. Your parents and the accountant were the only people with that information. They were the only ones who knew that income taxes were not being paid or what was going on financially within the company. Due to this, we believe that we will be able to prove that you are not liable to pay $20,000 under the trust fund recovery penalty.
Hello. My name is Jeremy Martin, and I will be describing the appeals process that we intend to pursue for your case. As your case falls under the $25,000 threshold, we will be pursuing the small case request process for appeals. This process entails submitting an appeals conference request, which you have been provided, in response to the letter you received from the IRS. This appeals conference request was prepared and provided for your review prior to submittal, outlining the basis for the appeal. First and foremost is the request for an appeals conference. The appeals conference is the opportunity to dispute the penalty assessed to you by the IRS with their internal appeals division. The appeals office is separate and independent of the IRS investigator that conducted your initial review. By appealing directly to the IRS, we hope to avoid the necessity of court to dispute the assessed penalties. The appeals conference request goes on to describe the basis for the appeals, which in your case is multifaceted. As you are being charged for the trust fund recovery penalty, the IRS is required to demonstrate you are both a responsible person and willfully withheld the tax payments for the employees. It is these aspects that the case will be made based on your unique position in your parent's company. The appeals conference request will be sent to the examiner and from there forwarded to the local appeals office. Appeals conferences can occur in person, through correspondence, or by telephone, a detail that we will discuss more in the future as the appeals conference can occur with your authorized representatives.
Hello, Ainsley. The letter that you received states that the IRS imposed the Trust Fund Recovery Penalty, or TFRP, on you. The penalty is for violation of either not collecting employment taxes or collecting those taxes and not remitting payment to the IRS. If the IRS does not collect these taxes from a business in a timely manner, they will typically apply the trust fund recovery penalty on the business, which is what is happening to Tuba Toothpaste. Although Tuba Toothpaste is no longer in business, a declaration of bankruptcy does not nullify this penalty. For this penalty, the IRS will first identify a responsible person and then deem that the responsible person willfully neglected to pay these employment taxes. In this case, the IRS has identified you as a responsible party since you held the title of CFO and Treasurer for Tuba Toothpaste. Our firm will help you write a letter of appeal to the IRS stating that you had no prior knowledge relating to matters of employment taxes. We will also guide you in an appeal conference so that you can state the facts of the case. At this time, you do not need to remit payment of $20,000 as we help you with the appeal. If the appeal is not successful, we will explore further options that include appealing to the U.S. courts to hear your case. We do not anticipate having to do this, but it is available as an option.
So, we will insist that you need not to pay trust fund recovery penalty. You may be responsible for the operation in appearance. You were the CFO of the company and signed some tax payments. But the accountant and your parents oversaw the tax payments. You didn't know anything about the tax payments on the business. Also, this tax unpaid was not intentionally made by you. So, with the adequate evidences, we are confident that the IRS will understand our claim. We are looking forward to seeing you next time. Thank you. Bye-bye.